which is better for the prosecution? Is it the archiving or the tabling? Which would you have preferred?
It would have been the tabling. Because should the Supreme Court grant us relief, all that the Senate has to do, or the Senate has to do, is to reconvene as impeachment court. However, with the archiving, the court, the Senate has had introduced a new innovation, archiving, which means before the trial would resume, they would have to, someone would have to make a motion to revive the articles from the archive, and they would have to vote.
So it requires another step.
2 steps. 2 steps.
Ang sabi naman po ni retired Justice Ascuna ay pag naka-table ay maaaring ma-dismiss. Pero pag archive, pwedeng mabuhay ulit.
Hindi po. Yan ang pananaw ni...
Yan ang pananaw niya.
Opo. Iba ho yung, magkaiba yung aming anggulong tinitingnan eh. Magkaiba po.
Okay, you filed a motion for consideration before the Supreme Court. May I know what is in there? What are you asking them to reconsider exactly? It's been discussed that there could have been errors in facts. What is included in the MR?
How much time do you have for me to
enough
explain?
Time to break this down for our audiences in a way that people could understand.
I'll encapsulate the arguments. The decision said, first, that the House of Representatives neglected and willfully took in action. They did not take action on the first 3 impeachment complaints. That's wrong, because the House took action by including the 3 complaints all together at the same time to plenary within the 10-session day period required by the Constitution. Second, the decision faulted the House Representatives for entertaining the 4th impeachment complaint, considering that it has violated the 1-year bar rule by reason of the inaction and archiving of the first 3 impeachment complaints, which the Supreme Court considered as dismissal, okay, and therefore considered as the initial action. So mali din po yun. Third, that the Vice President was deprived of her right to due process. Fourth, the court introduced innovations that were not in the Constitution by providing guidelines on how future impeachments under the second mode, which is endorsement by 1/3 of the members of the House. They introduced 7 requirements which were never been heard, which have been unheard of and not in the Constitution. And then finally, they applied their ruling, this new doctrine, which overturned Francisco and Gutierrez, these 2 cases, retroactively, not prospectively.
So yun po yung mga arguments natin.
Yes,
But-
7 points.
But